SJC-12905, Commonwealth v. Ricardo, Montarvo.
Thank you. Ms. McGillen.
Good morning. May it please the court, Ines McGillian here for Mr. Montarvo. The sole issue on this appeal is whether the trial judge in this case had discretion to sentence Mr. Montarvo to straight probation under Section 25A of the Habitual Offender Statute. The Habitual Offender Statute was significantly revised in 2012 to provide for gradation in its recidivist sentencing scheme, and it created more serious penalties for violent reoffenders under Section 25B, and at the same time provided significant procedural and judicial review protections for them. Mr. Montarvo is asking this court to rule that the various means of sentence mitigation expressly revoked for 25B offenders, in particular, the discretion to impose straight probation, remain available for ordinary reoffenders under Section 25A. As this court stated in Commonwealth versus Zapata, when the legislature intends to bar probation, it knows how to say so explicitly. And indeed here, for 25A, it would need to revoke probation or bar probation explicitly to expressly supersede the existing probation statute. That's Section 87 of Chapter 276. If 25A is unclear in any way, then the rule of lenity requires that it be read to permit a probationary sentence. The 2012 amendments created two categories of recidivist offenders. And under Section 25B, it enumerated a large number of violent felonies that qualified for more severe sentencing under Section 25B. Section 25A is now a general recidivist provision for general reoffenders guilty of any 3 felonies carrying sentences of 3 years or more. 25B makes violent reoffenders ineligible for probation, parole, work release, or furlough, or good time credit.
Right. Counsel, may I interrupt you for a minute? There were anyway, several proposed amendments that did not pass. They were from 2019. And those, one was in the House, one was in the Senate. There were several of them. And they would have given, one of them would have given parole at 35 years if there'd been a life sentence, but another one would have said that 25B should be applied to 25A offenders. Should we read anything into the fact that this was not passed? Does it help your argument? Does it hurt your argument?
Well, I know just as a matter of statutory interpretation, bills that don't pass, it's very difficult to read anything into them about the intent of a prior legislature.
Right.
So having not studied these proposed amendments or any of the reasons for their rejection, I'm not really prepared to answer that question intelligently.
Ms. McGillen, could you elaborate, please, on your 16L letter in Commonwealth versus Billingsley?
Yes, well, my reading of that case is that this court has empowered the appeals court to conduct 33E review of 25B sentences. And it has also provided guidance to the appeals court on how to conduct that review. And among the powers under 33E review, the appeals court can reduce a 25B sentence to a 25A sentence or remand for resentencing under 25A. And implicit in that decision, and in footnote 24, this court actually suggests that the list of expressly revoked sentence mitigation measures are available to offenders sentenced under 25A.
Is that an offender sentenced to life?
Life
or
any
anyone?
Of years. My understanding is for life or any, I mean, my reading of Billingsley is that 33E review is available for any 25B sentence regardless of the length of the sentence.
Can I ask,
I have one sort of concern. I see your argument that 25B is express and 25A isn't. But the result you're producing is that 25A, which is pretty draconian, will now be converted into a probation statute, isn't it? You're basically, that's the alternative, right? You got to give that sentence, but you give it, so it turns what the legislature wanted to be a big punishment into probation, it seems like. It just seems odd to me. I'm not saying you're wrong, but it just seems strange that 25A becomes basically a probation provision under your interpretation.
Well, Your Honor, I don't agree that it turns 25A into a probation statute. It certainly preserves probation as one of the options available to a judge.
But it means, right, it turns, the judge either gives a huge hit or probation. There's nothing in between, right? Is that what?
It provides for calibrated justice. And the interesting thing about your question is that it presupposes that there is some kind of normative standard for what a recidivist statute is meant to accomplish. And there is no normative standard.
Well, but let me just pose, and it may be that I don't understand it, but basically it ends by saying for such felony for the maximum term provided by law, right? So the judge has a choice. It's not a calibrated choice. It's either you give the full term or you give probation for the full term, right? That's the only choice.
Correct.
That seems less than calibrated. It seems kind of like you're either giving a big hit or no hit. It's just a strange dichotomy, isn't it?
It is, and Judge, you may be advocating for the reintroduction of split sentences, but there's an existing statute that has expressly revoked split sentences. And yes, here it is an anomaly that a defendant could be sentenced to either the max or probation. But it's very clear from this statute that, well, first of all, just to respond to your point about is this weird or not, a recidivist statute only accomplishes what the legislature says it accomplishes. There's no moral or normative standard for what it's supposed to do. There's no standard for recidivist statutes eliminating all sentencing discretion and mandating incarceration in every case. These statutes were generally enacted after the First World War to respond to crime increases, and their iterations vary from jurisdiction to jurisdiction. Several jurisdictions have gradations in recidivist statutes that account for differing levels of culpability. And the availability of probation here is still punitive because a man or a woman who violates probation is nevertheless subject to the statutory maximum. Now, it may be that there may be greater procedural protections for a 25B defendant than a 25A defendant after Billingsley, but it's an important tool that we need to keep in judges' arsenals because this statute was enacted with the backdrop of an existing probation statute that in every case permits a probationary sentence. And every penal statute in Massachusetts contains language saying shall be imprisoned for X term. No case has ever interpreted that language to mean that probation is unavailable. Indeed, whenever the legislature intends to make probation unavailable, it says so explicitly, and it hasn't done so here. So it may be that a judge is faced with probation versus the max, and if that's weird, the legislature is free to amend the statute.
Well, I'm just going to throw you a lifeboat for a moment. There can be more than one indictment like there was here.
Correct.
And there could be a 20-year or probation and imposed probation and imposed a 10-year mandatory minimum.
Correct. And particularly because the recidivist statute gives the prosecution so much power in charging to defendants' exposure. Here, what Mr. Montarvo is likely to argue on remand is that the judge has the discretion to impose a probationary sentence on the 20-year count and sentence him to 10 years. And his probation could be on and after the 10 years served. And by all indications, the sentencing judge felt that he had no discretion and even apologized to Mr. Montarvo. So at minimum, the availability of probation is a calibration tool that's still available to judges. And if the legislature wishes to change that, they can amend the statute. That said, I should also point out that this statute actually requires plea colloquy warnings to 25B defendants. And it would make absolutely no sense if that entire list of sentence mitigation measures were unavailable to 25A defendants. And my argument is basically that the statute has made them unavailable to 25B defendants, and that ineligibility is so serious that it requires plea colloquy warnings in every case. And just to be clear, Mr. Montarvo is not arguing that he should be entitled to argue for a suspended sentence. The option of suspended sentences was removed by the Truth in Sentencing Act in 1993, and this statute is in harmony with that prior existing statute. But in essence, Mr. Montarvo asked to have his sentences vacated and remanded for resentencing under 25A with a clear statement by this court that probation, straight probation, remains an option under 25A.
Any further questions, Ms. McGillian?
No, thank you.
Thank you, counsel.
Thank you.
We'll hear from Ms. Woodard, please.
Good morning, and may it please the court, Assistant District Attorney Shana Woodard on behalf of the Commonwealth. Your Honors, in this case, the sentencing judge correctly concluded that he did not have the discretion to sentence the defendant to anything other than the maximum term allowed by law, which was the 20-year sentence. The statutory language in 25A specifically states whoever is convicted of a felony and has previously twice convicted and sentenced to state prison or state correctional facility or federal correction facility for a term of not less than 3 years on 2 prior occasions shall be punished by imprisonment in state prison for such felony for the maximum term provided by law. The Commonwealth would argue that this is not ambiguous at all, that the legislature has explicitly stated that probation is not on the table by saying that the defendants, if they are convicted under the statute, that they shall be punished by the maximum term.
But counsel shall be punished by that. So the sentence would be imposed, and then suspended, and probation imposed. It's still imposed, isn't it? It's still a mandatory use. This is the sentence, but all the other sentencing options would go along with it, wouldn't it?
Well, there is no possibility of a suspended sentence on what the defendant was convicted of because he was convicted of armed assault with intent to murder, which does not have the possibility of a house of correction sentence. It's only. Yeah,
but you're going back to a different sentence, correct? I mean, a different statute at that point.
So we're
outside of this one.
That's the underlying statute that he was convicted of. The habitual criminal statute is a sentencing enhancement, and the purpose of the enhancement is to punish more severely people who continue to be convicted of crimes and sentenced to state prison.
Why do you think the legislature made a distinction between 25A and 25B crimes?
I believe that the purpose of the amendments in 2012 was to punish even more severely and take away the possibility of parole or the ability to get good time for people who were convicted of the enumerated offenses in Section 25B.
So if they're not convicted of the enumerated offenses, then what's the point of 25B? I mean, it wouldn't apply to them, right?
I don't understand the question, I'm sorry.
Well, if they're not convicted of one of the enumerated offenses in 25B, how does the no parole, no probation, no suspended sentence, no whatever, how does that apply to those convicted of 25A? They haven't been convicted of the crimes under 25B, if that's the point of the legislation.
So I think it's clear, both the legislative intent and also the cases that this court has previously decided that Section 25A is essentially the same as the prior iteration of the habitual criminal statute, with the exception that it allows for suspended sentences and federal sentences, and that all of the prior assumptions about the prior iteration of 25, the earlier version of the habitual criminal statute still stands, and that this court specifically has stated that that means that they shall be imposed the maximum sentence, and that they do have the possibility of parole under Section 25A.
Okay, I guess, well, so do you agree that if we looked at if we forgot everything else and just read the statute as if that's the only thing we have, would you agree with your sister that if we look at the plain context, the plain language of the statute, that the defendant would be correct in the way we should read it? If we just look at the language.
I think that the plain language of the statute is clear that it's the maximum penalty. I don't think that there is the possibility of probation given the way that the statute is written and the purpose of the statute.
But why wouldn't the crime have been put in Section 25B then?
I don't understand what you're asking.
Why bother with 25B if 25A has no meaning?
I would suggest that 25A does have a meaning. 25B, the purpose is to punish them even more severely. There is not the possibility of parole even, which I would suggest is under a different statute. And it's clear from the 2012 amendments that the parole statute was amended at the same time in 2012 to reflect that subsection 25B does not allow for the possibility of parole.
Okay, do you think that there's any value or information we can glean from looking at the proposed amendments to the statute?
I would suggest the same as my sister has stated, that given that it hasn't been imposed, and I'm not sure exactly what the reasons for the legislature not voting to amend that shouldn't really be looked at. It should just be looked at the prior cases of this court and the legislative intent and the language of the statute as it's written.
I'm confused now. So
I've done my job then, Judge.
yeah, not by you yet. So the statute 25B has this critical sentence: no sentence imposed under this subsection shall be reduced or suspended, nor shall such persons so sentenced be eligible for probation, parole, work release, or furlough, or receive blankety blank. 25A doesn't have that language, right?
That's correct.
So does that mean under 25A you can do all these things or not? I'm confused. And if you can't, why didn't, what is the significance of its absence? I'm just trying to understand that.
What the Commonwealth would suggest in this is that essentially what defense counsel is trying to argue is that because it's not there and it is explicitly in subsection B, then that means that the legislature intended for probation and all of those other possibilities to be allowed for in A. And what the Commonwealth would argue is that essentially that's making an assumption based on the maximum negative implication.
Well, but we got to make sense of, these are two provisions right next to each other. We've got to make sense of that language. So help make sense of that. You can't just ignore that that language exists. She's got to be right unless you can explain some reason why they treated them differently that I don't understand yet. So tell me why.
So I believe it's because the legislature was essentially, subsection A is the same as it was previously, and that all of the prior implications of that statute, which included that there wasn't the possibility of a suspended sentence, of probation, but there is the possibility of parole, stands, and that they explicitly added additional limitations on it for specific crimes that are enumerated in subsection B.
So they just added, even though all of this is covered by 25A in your view, absolutely all of this is prohibited. They decide to say it again for no reason?
Well,
What does this add? This language has got to add something for these particular crimes, or it doesn't make any sense, right?
so the Commonwealth's position is that essentially, because subsection B, C, and D are new, they're entirely new. There has been no legislation or case law on those particular issues because they were added in 2012. They had to be as explicit as possible in those subsections. Whereas,
why? Because it's all, in your view, it's all covered under. You could have the same for all of these things. 25A, right, does the job for you, right? You don't need 25B at all, according to you, right?
no, because under subsection A, an individual does have the possibility of parole. There would be the possibility that they could get good time if they weren't sentenced to a life sentence. So there are a number of differences after they're convicted.
So the duplicative language is the word probation. That's just the superfluous language. The rest of it serves a purpose.
I would suggest that that is correct, but I would also suggest that Your Honor should take a look at the legislative intent, but also the prior cases that this court has decided, particularly where I believe it was in Garvey, this court had stated that the legislator, because they did not further amend subsection 25A, there is no indication that it intended to make material changes to the rest of 25A, and that to the extent that 25B includes more specific languages about distinct occurrences, this does not negate the courts and the appeals court's prior assumptions about subsection 25A. And this court has repeatedly stated that under the habitual criminal statute, that the defendants aren't entitled to probation, that they shall be convicted and sentenced to the maximum terms by law.
Do you,
So-
I'm sorry, did that answer your question, Justice? Can you address, if you can, I know that it came in as a 16L letter this morning, but can you address Billingsley and how that might apply to this?
Absolutely. In Billingsley, the court wasn't addressing this particular issue. It was regarding a 33E review under subsection B and whether or not the appeals court had the ability to conduct that review. The footnote that is addressed, I believe it's footnote 24, is clearly dicta. It was not an issue that was fully briefed or argued before this court, and the Commonwealth would suggest that given this court's prior decisions, that the court shouldn't consider the footnote in that particular case, again, because that wasn't an issue that was raised on appeal.
Ms. Woodard, isn't it possible that Section A just may not do what the legislature had hoped it would do, and they may fix it if they want to?
I suppose that the court could find that. I would suggest that, and counsel had argued Zapata pretty heavily in its initial brief to the court, and I believe that the court essentially came to that conclusion in Zapata, but what the Commonwealth would suggest is that Zapata is significantly different than this case, that the home invasion statute was the original underlying felony, and that this court found that the reasons that the court found the particular way that they did was because of the very unusual legislative history of the home invasion statute, and that but for that particular history, this court might not have found that there was an allowable probationary sentence underneath that, especially because the home invasion statute originally had language prohibiting probation, and the amendments that were at issue in Zapata it actually took out language regarding probation. So where here, there wasn't taking out of specific language in the original habitual criminal statute, which is embodied in subsection A, the Commonwealth would suggest that that it should be viewed in a different light.
But ultimately, your argument is that 25A is different because you can receive parole and you can receive earned good time on a 25A sentence. And that 25B, you can't have that because they have that magic language that makes it a real mandatory minimum. However, you don't make the same argument for probation, that probation's available under 25A. And the reason you say that is because it says that the maximum sentence has to be imposed. That's your argument, isn't it?
Yes.
Counsel, I have one final question, and that is, does 25A give you any charging discretion to charge some of the crimes listed in 25B under 25A?
So are you asking if the Commonwealth could use its discretion and only charge under subsection A, even if they qualified for subsection
Yes,
B?
right.
Yes, I think that the Commonwealth could use its discretion in that manner.
Okay, thanks.
Any further questions? Thank you, counsel.
Thank you.